Hi guys, my name is Joseph Tapiwanashe Dhayimani. I'm a law student at African University, and my law lecturer for law of evidence is Mr. N Maphosa. So today, I'm going to be presenting about scientific forensic evidence. Scientific forensic evidence is the application of science within legal proceedings. The analysis of key data within court proceedings can help establish the guilt or innocence of possible suspects. This means that the basic for evidence has been hypnotized and tested and is generally accepted within the scientific community. These tests tend to be conducted via scientific, medical, or technological means. This could mean that the theory on which the scientific evidence is based has been published in scientific journals, and this has been subjected to peer review within the scientific community. Fingerprints and body evidence is admissible, and in the right circumstance it can be of considerable probative value, particularly in criminal matters. So scientific forensic evidence is usually used in criminal matters. Note that the term body print is now used to refer to a palm print, footprint, or other similar evidence.
Moving on to types of scientific forensic evidence. Fingerprint and body print evidence is another type of scientific forensic evidence. Fingerprint evidence is perhaps the best known and most widespread of the forms of scientific evidence commonly used. Usually, the police left fingerprint found, for example, at the crime scene and send them to police fingerprint experts for analysis. These experts then compare the prints to those on the database to identify the person. Alternatively, where fingerprints from a suspect have been taken and sent for analysis, the two sets of fingerprint can be compared. If there are sufficient points of similarity, the accused norm is that 7 points are sufficient. The prints are regarded as being those of the individual concerned and will carry whatever evidentiary implication the same circumstance in which they were found would indicate. For example, they may indicate the presence of an accused at a crime scene or the identity of a body. Evidence of points of similarity is usually presented by way of affidavit, although it may be done orally. Sometimes evidence is presented with a comparison chart describing the way the comparison was made, commenting on the points of significance, providing an opinion, and providing reasons for the opinion expressed by the expert.
Over to types of scientific forensic evidence is the polygraph and voice analyzers. A polygraph is a device that measures and records momentary physiological changes in respiration, blood pressure, heart rate, pulse, and skin current associated with the sweating of palms, which take place in response to questions put in an examiner. Generally, an examiner asks the examining questions, some of which are directly relevant to a specific matter under investigation, while others are unrelated to the matter. Although commonly referred to as a lie detector, a polygraph does not measure lying or deception. It merely records physiological activity in the examiner. An examiner then puts purports to infer from the
recorded physiological results that an examiner was deceptive in answering questions relating to a factual issue. The theoretical assumption underlying the use of polygraph testing is that a fear of detection will produce a measurable physiological reaction in a person who knows that he or she is lying. According to the polygraph measure the fear of detection rather than deception itself. This analyzer is a monograph, not a polygraph, because only one physiological response is focused on the voice. That count in Langofisa CIM Tech Galan CMM Tech refused to admit the results of voice stress analyzer on the basis that the voice patterns differed greatly between cultural groups and that there is no universal system of voice patterns reflecting emotions as there is, for example, in the case of fingerprints. The court found it unacceptable for the respondent employer in the case to use an American voice analysis test to examine black South Africans for the purpose determining whether they were telling the truth. We have DNA evidence. A far more precise method of identification is to be found in the so-called DNA fingerprint. Section 36A, subsection 1 in Chapter 3 of the Criminal Procedure Act defines DNA as deoxyribonucleic acid, which is biochemical molecule found in the cells and that makes each species unique. What follows is a basic description of DNA as a means of identification, the scientific basis thereof, and the process involved. Humans have 46 chromosomes in the nucleus of each somatic robot cells. These thread-like structures are composed of a linear arrangement of genes which in turn are made up of DNA. The DNA of each individual is unique, except for identical twins. A person's DNA resembles that of his or her parents because one member of each of the 23 chromosome pairs comes from the mother and one from the father. DNA can be extracted from cells taken from skin, bone, blood, hair, fossils, and semen. This DNA can be used in a laboratory test to show a distinctive pattern of bends. This process is known as DNA fingerprint. The pattern that is derived can then be compared with other samples of DNA to determine if there is a match. The DNA evidence that's obtained can be used for several forensic purposes. It can determine the identity of a deceased person where other reliable means are no longer possible. DNA taken from the skeleton, for example, would be similar to that of the parents of children of the deceased. In paternity disputes, a sample of DNA from the child is compared with the DNA of the mother and the alleged father. In S versus Matley, they expect evidence based on DNA analysis was to the effect that there was a mere 0.06% possibility that the appellant was not the father. DNA tests can be used to link a suspect to a crime or to show that the suspect could not have been the perpetrator. In a rape case, for example, semen found on the victim can be analyzed and compared to the DNA from blood samples taken from the suspect and the victim. DNA profiling is a more useful forensic diagnostic tool than simply using blood types. S versus R. Willis, the judge said that, in my view, there are substantial benefits to be derived from harnessing the advances in modern science to the law. When it comes to rape cases, DNA testing can be especially helpful. The testing process, like all other scientific processes, must be executed and recorded with such care that it can be later verified by an objective scientist. And for territory, also a court of law, S versus SB, contains valuable insights into the technical and scientific basis upon which DNA evidence rests. In the case of Van der Mare, J expressed his debt to the Mendelis Van der Waart book Journey in the Courtroom, Tested Principles and Practices, which was published in 2010 and which has often been referred to by South African courts. Expert medical and scientific evidence is obviously required, and non-expert evidence should not be accepted. In Gist vs. Agent Others 1994, the court pointed out that blood samples are valuable aids to criminal investigation. However, in terms of Section 45, Section 3 of the Criminal Procedure Act, the process of extracting a blood sample can only be instituted by the submission by a police officer or above the rank of superintendent of a written request to a medical practitioner. The test had to be performed by a medical practitioner. The police were expressly excluded from doing so. The suspect has the right to be informed of who was to take the sample, where and when it was to be done, and the purpose for which it was required. Where the taking of blood sample is lawful, when reasonable force could be used to obtain it, the police can thus use reasonable force to compel a suspect to submit to the taking. Only the officials mentioned in Section 45, Subsection 3 are authorized to take blood sample, although they could delegate their duties to other persons. The accused cannot insist that other persons take. Moving on, footprint evidence is another type of evidence. Footprint evidence does not necessarily require expert evidence, unlike fingerprint and body print. Footprints will be admissible if it is assessed in the court. Such evidence is admissible subject to the standard requirement of all opinion evidence, namely that it is of appreciable assistance to the court. The circumstances under which such evidence will be of assistance to the court vary. For example, the footprints may be either showed or unshowed. Plaster casts or photographs of footprints are readily examinable by the court itself without the need for opinion evidence. However, a bare footprint may be treated like a fingerprint or a palm print and would thus require opinion evidence. When dealing with the issue of identification, it is permissible for the court to rely on evidence relating to bare footprints. However, a number of precautions have to be observed before such evidence can be accepted. It is certainly not enough for a witness to make a bold assertion that the footprints were those of the accused, even if he says he had lived together with the accused in the same area for some time and he knew those prints well. The witness must be asked by what characteristics or peculiarities, marks or indications he recognized the footprints as being those of the accused. The ability to give a precise and detailed description and point to features of a unique distinction will point in the direction of reliable identification.
Cases in which the identity of the footprints of the suspect forms a vital part of the state case, the police should, wherever possible, take a cast or other impression of the footprint at the scene of the crime and a comparative footprint from the accused. This should then be produced in court as exhibits so that comparison can be made. In respect of bare footprints, an expert in handprints may also have the expertise to conduct an expert comparison between the two sets of footprints. Reliance on shoe prints is obviously fraught with considerable danger, especially when the shoe print is from a type of footwear which is in widespread use. In Commonwealth and another, it was stated that, broadly speaking, good identification does not need corroboration or support, but poor identification does. Examples of good identification include cases where the witness has observed the accused over a length period or many times, or where the accused was well known to the witness. The identification will be unreliable if, for instance, the witness caught only a fleeting glimpse of a person from a considerable distance in poor light. The identification in these circumstances would be doubtful, whether or not the person was a person he had known previously. On the other hand, close-range observation for a reliable period of time in good lighting conditions where the witness clearly saw and carefully studied the person's facial features will be far more reliable, particularly if the person was well known to the witness